You're watching The Legal Breakdown. So we've got some shocking news out of Florida where Judge Cannon has now threatened Jack Smith with sanctions. So we're going to discuss that right now. But first, a quick note for our viewers. This is our 300th episode of The Legal Breakdown. We just want to say thank you to everybody for tuning in. And if you're not yet subscribed, please consider subscribing, especially as we await a verdict in Donald Trump's New York criminal trial, which we'll discuss in a separate video. But going back to Florida, Glenn, what happened here with Judge Cannon, and why is she now threatening Jack Smith?
So, Brian, Donald Trump in recent days has been posting and making statements that include outright lies, and they're basically violence-inducing lies against the FBI or about the FBI, falsely claiming that when they executed the search warrant at Mar-a-Lago, the FBI was authorized to and prepared to shoot Donald Trump and injure his family members. We're going to read one of those lies in a moment. So, of course, with Donald Trump engaging in that kind of extremely dangerous rhetoric, Trump-appointed Judge Aileen Cannon decided to threaten Jack Smith with sanctions. Why? Well, because Jack Smith filed a motion a few days ago with Judge Cannon saying, Judge, we can't have a defendant who's on pretrial release. Remember, Donald Trump is still on pretrial release in 4 felony cases, 2 state and 2 federal. We can't have a defendant on pretrial release posting abject lies that are very likely to incite violence against FBI agents, against FBI field offices. We've already seen some of Donald Trump's supporters inspired to violence against, for example, I think it was the Cincinnati FBI field office. So Jack Smith filed a motion asking the judge to please modify the conditions of Donald Trump's pretrial release so that he can't make these obviously false and, very dangerous assertions, putting the lives of FBI agents at risk. So Judge Cannon took a look at the motion and she said, you know what? I don't think you conferred sufficiently with Donald Trump and his lawyers before you filed this motion, so I am threatening you, Jack Smith, with sanctions. So here's the thing. She didn't care one whit about the violence-inducing lies Donald Trump was telling. And let's talk about this obligation of the parties to confer with one another before they file a motion. It is a thing. I did it hundreds and hundreds of times with defense attorneys. I would say I'm contemplating filing a motion to ask your client to stop lying and inciting others to violence. Will your client agree to stop? No, he won't. So do you oppose this motion? Yes, I do. There, we've conferred. And I put that very information in the motion I filed. We conferred with opposing counsel, and they said they ain't going to stop, and they oppose the motion to modify the conditions. But Brian, we need to just back up a little bit to the motion that Jack Smith filed that got this ball rolling. A couple of days ago, Jack Smith filed a 12-page pleading in the Florida classified documents obstruction of justice espionage case pending against Donald Trump. And he asked the judge to modify Trump's conditions to make him stop lying and endangering the FBI. Here is some of what is contained in that motion. This is what Donald Trump said. Now, mind you, in this motion, and this gets my blood pressure rising, in this motion, Jack Smith said, when we executed the search warrant at Mar-a-Lago, we did a couple of things. First of all, we conferred with Donald Trump's lawyers in advance of the search warrant being executed. Now, listen, I don't like to jump on prosecutors, but when I see them do something that I consider inappropriate, I'm going to jump on them. That is borderline law enforcement malpractice. We never give the target of a search warrant a heads up that we're about to execute a search warrant. Why? Because then they destroy evidence, or they tamper with witnesses, or maybe they move classified documents, that are all boxed up from one place to another, so that now that they know the FBI is coming to search Mar-a-Lago, they, can avoid having all of the boxes recovered. So it was mind-boggling when I saw in this motion that the FBI coordinated with Trump's lawyers in advance. But here's the more important part. They made sure that the date they set for the execution of the search warrant at Mar-a-Lago, August 8th, 2022, they made sure that Donald Trump and his family members would not even be in the state of Florida, never mind not be at Mar-a-Lago. Knowing that, Brian, here is some of what Donald Trump posted that inspired Jack Smith to file this motion. He said, "The FBI was authorized to shoot me and just itching to do the unthinkable and was locked and loaded and ready to take me out and put my family in danger." You see the lies he told there when the FBI coordinated before the execution of the search warrant to make sure Trump and his family would not even be in the state of Florida. This is the kind of call to violence that we've seen from Donald Trump over and over and over again. And so Jack Smith appropriately conferred with the defense, told the defense, we're going to be filing this motion. Will you confer with us? Do you oppose it? Here's what they said, Brian. We oppose it. And by the way, this is a holiday weekend, so we're not interested in conferring with you fully right now. How about a week from Monday? Jack Smith said, you know what? We've conferred. And he put that information in the motion. And after that brief conferral, as they call it, just hours later, Donald Trump again posted calls to violence, false information, by saying, just a few hours later, Donald Trump made a statement claiming the FBI was authorized to use lethal force on Trump or anybody at Mar-a-Lago, while the FBI and the DOJ plants evidence to frame Trump. So even after the admittedly brief conferral that the defense wanted to put off for more than a week, Donald Trump continued to post lies that were obviously calls to violence or potentially calls to violence. So what does Judge Cannon do when she gets her hands on Jack Smith's motion? She threatens to impose sanctions on Jack Smith because she doesn't think Jack Smith's prosecutors gave the defense attorneys adequate time to confer, even though I just laid out the sequence of events that makes it clear they weren't interested in conferring. They wanted to delay the conferral. And during that delay, Donald Trump continued to post lies. This is Judge Cannon acting, and the word that came to mind when I read what's called the minute order, a very short order that was published by Judge Cannon setting out her threat to sanction Jack Smith. This is asinine. This is not conduct befitting of a federal judge, somebody who not just ignores, but I would argue encourages continued violence-inducing lies by a defendant on pretrial release, and instead of addressing it, she yells at the prosecutor. This is the criminal justice system turned on its head.
Glenn, for posterity here, just very quickly, can you talk about the fact that this is standard language, the fact that they're able to use force to execute a search warrant, and that doesn't change even with regard to the search warrant that was executed for President Biden?
Yeah, so Donald Trump started screaming about how the FBI was authorized to kill me. And then Steve Bannon, you'll remember him, he is about to report to federal prison any day now to begin serving his 4-month sentence. He took it one step further, and he said this execution of the search warrant at Mar-a-Lago was, quote, an assassination attempt. Now, first of all, I would say if that were true, which it's not, it would have to be the most incompetent assassination attempt in the history of law enforcement. Because they told Donald Trump's lawyers, we want to coordinate so that we do this at a time when neither Donald Trump nor his family is in the state of Florida when we try to assassinate him at Mar-a-Lago. Give me a flippin' break, Steve, right? But Steve Bannon took it one step further. So, and here, the point that you're getting to is an excellent one, which is every single ops plan, an operation plan, and I was involved in many What happens is before a significant law enforcement operation kicks off, like the execution of a search warrant, agents, sometimes in conjunction with prosecutors, will sit down, will come up with an operations plan to make sure they have all contingencies covered. There is a standard rule and procedure when the FBI is involved in any law enforcement operation, including the execution of a search warrant. And that says that FBI agents may only use deadly force to repel a lethal attack. In other words, that is standard language in every single law enforcement operation. If police are met with deadly force and they need to repel it by using deadly force to protect the lives of the agents or the lives of members of the community, only then are they approved, are they able to use deadly force. This standard procedure, and it's not only the FBI, it's every law enforcement agency in the country operates under this same standard procedure. This somehow morphed into Donald Trump and Steve Bannon saying that, oh, the FBI was authorized to kill me and they were itching to do so and to hurt my family. Again, this is the worst kind of lies and propaganda and BS that Donald throws into the public square to try to, one, undermine law enforcement, and two, incite and inspire his supporters to violence.
Glenn, I know I sound like a broken record here, but to what extent do you think that all of this Jack Smith being hit with the threat of a sanction, was entirely predictable given his own refusal to seek Judge Cannon's removal? Like, are we supposed to be surprised that the judge is now acting in an entirely hostile manner to Jack Smith when we've all known all along that she's in the tank for the defendant, and yet prosecutors perplexingly refuse to actually take any action against her?
Yeah, I can't say the word. Perplexingly is exactly the right word. I mean, there's nothing but downside for Jack Smith. Judge Cannon couldn't be more antagonistic toward Jack Smith, and she couldn't be acting to the benefit of Donald Trump any more than she already is. Right. I don't understand why Jack Smith hasn't filed a motion seeking her recusal. Let her deny the motion and then appeal it to the 11th Circuit Court of Appeals, and let's litigate the issue in the full light of day and get it resolved by an appellate court panel of fair, impartial, independent judges. And let's never forget that Judge Cannon was reversed previously by the 11th Circuit Court of Appeals for abusing her judicial discretion by telling the FBI and the Department of Justice to stop investigating the crimes of Donald Trump that were exposed when classified documents were recovered during the execution of this very search warrant we are now discussing. So she already exposed herself as abusing her judicial discretion and doing something that the law does not allow to the benefit of Donald Trump. Why Jack Smith has not seen fit to file a motion to recuse continues to perplex me. The other thing I will say, though, is if she ultimately denies this motion, and here is the wiggle room Judge Cannon has given herself by threatening to sanction Jack Smith. She said, at this point, because I don't think you've conferred enough with the defense, again, which is asinine, I'm going to deny your motion without prejudice to refile after you talk to Donald Trump and confer, more substantively. Then I'll see if I want to grant your motion to modify Donald Trump's conditions to tell him he can't lie like this and endanger the lives of FBI agents. So if she ultimately denies it on the merits, which she is very likely to do, that's something that Jack Smith can appeal. And that may end up being a vehicle to then include other things that the appellate court might need to take up, like whether Judge Cannon's impartiality might reasonably be questioned, which is the federal law standard for when a judge must be removed from the case.
Although, I would say he's already got plenty of predicate to actually do that. With the 11th Circuit decision rebuking Judge Cannon, with her bogus interpretation of the Presidential Records Act, which she threatened to give to the jurors, which would of course allow them to immediately dismiss this case against him, with delaying the trial indefinitely, even though it was Donald Trump's defense team itself that offered up an August trial date. I mean, you yourself say the recusal bucket runneth over. I think we've got plenty of predicate here. So if he hasn't taken advantage of the opportunity to seek her removal now, I mean, she's going to continue to give him more options to do exactly that, and it doesn't look like he's going to take any of them. I mean, like, if he didn't do it the first time or the second time or the third time, does he need a fourth opportunity to take advantage before he actually moves forward? Or are we just going to get the message at this point that he's not going to seek her removal at any instance because he's just not interested in doing that, no matter how hostile she's acting toward the prosecutors?
Yeah, Brian, I don't know. Maybe the eighth time is a charm. I'm not quite sure what benchmark Jack Smith is looking to hit, but I love that you brought up all of those other instances that expose Judge Cannon's lack of impartiality. And I think one of the big ticket ones was when the defense said they could be prepared to go to trial on August 12th, she said, no, I'm not setting any trial date. If that is not a sure sign that she lacks impartiality and has every intent on pushing this trial well beyond the 2024 presidential election, I don't know what was. And one other fact that I don't think we've discussed previously, it's come up in recent days. Judge Cannon actually made a statement during the most recent court hearing in this case that, you know what, this case may be too nuanced for a jury to even decide. What the hell does that mean? I've never heard a judge say that these charges, which have been properly indicted by prosecutors, might just be too nuanced for a jury to decide. I don't know if that means she's going to grant a motion to dismiss based on excessive nuance. There is no such thing, but let me tell you, she has distinguished herself as unfit to serve on this case over and over and over and over again. But like I say, maybe the eighth time is the charm.
Yeah. Let's finish off with this. I want to turn your attention to a question that I asked Daniel Goldman about this exact issue, about Jack Smith having enough of a predicate to seek Judge Cannon's removal. And this is what he said, because he pushed back on this notion. Do you agree with that decision? Because I have a lot of trouble kind of reconciling why he would opt not to do that, given that she's already very clearly hostile to the prosecution's case anyway.
Look, it's a very hard motion to win, and you would have to show affirmative evidence of bias in order to have her recused. And what we see are circumstantial facts that lead one to conclude that she is heavily favoring Donald Trump. But if she will have, or the court will look and say, well, if there is a plausible reason for her to do any of this, separate and apart from favoring Donald Trump, then you lose the recusal motion. And my guess is that the prosecutors want to be careful of that, because if they do move to recuse her, they want to make sure they win.
Well, doesn't federal law require that a judge has to step away from a case in which their impartiality, and this is a quote, might reasonably be questioned? Don't we have enough of a predicate to at least reasonably question Judge Cannon's impartiality here?
I'm not sure that we have legally enough of a predicate. And I guess that's different from, what our impression is, right, that there's clearly a predicate. She is clearly ruling in every way to favor Donald Trump, to delay things. It is also a lengthy and complicated process to deal with a classified document case. So that is a legitimate reason why these things generally take longer. But you would have to be able to show that there is evidence that she's being impartial. And simply ruling in favor of Donald Trump is insufficient to show that there's real solid evidence of that.
All right, so Glenn, your reaction to that?
Yeah, I take a different view. I have tremendous respect for Representative Goldman, former federal prosecutor himself. I first met him when we were both MSNBC legal analysts together before he went on to elected office. I take a different view, and I actually will just rely on the language of the federal law, which you actually cited to Representative Goldman in your discussion with him. You know, the federal law, for anybody scoring at home, it's 28 United States Code, Section 455, 28, 455. It says, any justice, it includes Supreme Court justices, I guess we can put a pin in that and talk about that in another video, any justice, any federal judge, or any federal magistrate judge, there are two different kinds of federal judges, whose impartiality might reasonably be questioned, not the highest bar, shall disqualify themselves from the case. Judge Cannon's impartiality not only might reasonably be questioned, it is reasonably being questioned by legal experts across the spectrum, and more importantly, by lay people who can see what she's doing and they understand intuitively, because you don't need a law degree, understand that when an appellate court, a three-judge panel of an appellate court, and Brian, two of the three judges that reversed her for abusing her discretion by doing something to Donald Trump's benefit that the law did not allow, two of the judges were Trump appointees. And the third judge was a Republican appointee, a three-Republican appointee panel. So let's take politics out of it. Previously ruled that Judge Cannon abused her discretion in favor of Donald Trump. That's for openers before everything else we've seen that we've been discussing. So, yeah, I respectfully take a different position than Representative Goldman. There's more than enough to file the motion, let her deny the motion, and then the American people we deserve to have this motion litigated in the full light of day so we can get a definitive ruling from a legitimate appellate court as to whether she should continue to be permitted to preside over this case. Because if we never litigate this issue, Brian, nobody will have confidence in the outcome of a trial that is presided over by Judge Cannon.
Right. Could not agree more. With that said, we'll continue to stay on top of this trial that's happening in Florida, as well as the trial that is quickly coming to an end in New York. So again, for those watching right now, if you want to follow along with all of that, including any imminent verdict that's going to be passed down in Donald Trump's New York criminal trial, please make sure to subscribe. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.